Hello viewers, in today we are going to discuss the concept of dispute resolution panel. I Komal Singh, legal researcher at Enterslice, going to explain you in this video what is DRP, when a person can approach the DRP, what is the approach of DRP, what DRP does during the proceeding, how was the matter finally concluded by the DRP. If the SSC is not agree with the solution provided by DRP, then what is the further remedial solution to him. So, through this video, I'll try to take you through all such points in summarized manner. So, to the first point, we would see why DRP. What is the need for DRP or dispute resolution panel? The dispute resolution panel is an alternative dispute mechanism set up to minimize the tax dispute relating to the taxation of international transactions and taxation of non-residents. What I mean to say is that in certain SSCs, not in the case of all SSCs, the SSCs where international transactions are involved and SSCs where taxation of non-residents is involved. In those cases, only the DRP worked as an alternative dispute mechanism. If I explain it in simple terms for you, rather than there being an assessment order directly on the assessment, the approach which is adopted in these two kind of cases by the Government of India is such that assessing officer will give you the draft assessment order. In assessment case, you will see whether you are agreeing with the draft assessment order or not. And if you do not agree with the draft assessment order that the assessing officers provided you, and if you are not agreeing with the draft assessment order, then you have to approach the dispute resolution panel. Now, what is the significance of the dispute resolution panel being there? The dispute resolution panel will see that what is the objection you are filing before it against the draft order provided by the assessing officer. Then accordingly it will issue the necessary direction to the which it wants that the assessing officer should modify accordingly. And probably this is why this particular thing is understood to be an alternative dispute resolution mechanism. Now let me put the second para before you. Also, this contains a process of inviting objection to the draft assessment order, which provides an opportunity for the SS to raise objections, if any, at an early date, or helps in giving finality to the assessment orders. Now, let me explain to you what is DRP. We have understood the background in which the DRPs are framed. DRP means a collegium comprising 3 principal commissioners or commissioners of income tax constituted by the Central Board of Direct Taxes. It means the Central Board of Direct Taxes will determine certain dispute resolution panel. Those dispute resolution panels will comprise a collegium kind of activity in which 3 commissioners or commissioners of income tax would be the sitting member of the DRP. The next question is whose cases may be referred to the DRP. This is a very important question to understand that only an eligible case of the SSC will be transferred to DRP. Now, who is the eligible SSC? First, any person in whose case the variation referred in subsection 1 arises as a consequence of the order of transfer pricing officer passed under subsection 3 of section 92 CA. Second, any non-resident not being a company or any foreign company with effect from 1st April 2020. The second point is very important because lot of non-residents are getting affected by this particular process. Rather, they are not in knowledge of this. The assessing officer might open up an assessment against them, and now assessing officer is giving them the draft order. Now they are thinking to file an appeal before CRTF, and this is not a correct approach. Wherever in your case the draft assessment order is passed by the assessing officer regarding section 144C, read with 144.3 and 144 them. You have two options to approach the DRP. If you are filing an objection to the assessment order which the assessing officer has given you in the form of draft order, and if you are agreeing with the draft order, then there is no need to file an objection before the DRP. However, if you feel you are not satisfied with the draft order assessing officer provided to you, then you have to certainly think of claiming relief through DRP. Now, let me put up before you what is the procedure before DRP. So, as I said, that the non-residents are one of the big categories who are presently facing the DRP related aspects, that they are not aware that the assessing officer giving them the draft and what to do next after receiving the draft. If the SSC is agreeing to that draft, then he has to pay tax, and if he is not agreeing to, then he has to file an objection before DRP. So, if in the case of the eligible SSC, the assessing officer shall prepare a draft assessment order and communicate it to the SSC. The SSC on receipt of such order within 30 days of the receipt of the order either file his acceptance of the variation to the assessing officer or file his objection to the such variation with DRP and assessing officer. However, if no objection are received by the DRP within 30 days of receipt of order by the assessee, the assessing officer shall complete the assessment based on the draft order. Where the objections are filed before DRP, it shall issue necessary direction to the assessing officer to enable him to complete the assessment. However, DRP before issuing any direction consider the following: draft order, objection filed by assessees, report of assessing officer, record which are relating to draft order, evidence collected by it, or result by the inquiry made by it. Now, I am going to discuss a very important point: what is the ultimate power of DRP? Ultimately, what the DRP shall do after hearing of your case, after looking at the records? It may either confirm or reduce or enhance the variation in the proposed draft order. These three are the three variations that may happen in response to the objection filed against the draft order. Now, the next question arises whether hearing the assessee is necessary for DRP. If DRP issues direction that are prejudicial to the assessees or in the interest of revenue, the opportunity of being heard by the assessee is must. If DRP is not agreeing to your objection, then it has to allow you to be heard. Now, millions of dollar question arises which I would like to add here. No doubt, then assessee may represent himself before DRP on his own, but certainly I suggest that you should avail of a service of consultant or chartered accountant or a tax consultant or tax advocate who can put up your case on the basis of the factual circumstances in the best manner before the DRP in your favor. If you require our team of experts who can put up your matter before DRP, please connect with our team at the number mentioned below. Now, what is the time limit of issues direction by DRP? The law says no direction shall be issued by the DRP after 9 months from the end of the month in which the draft order was forwarded to the assessee. It means whenever you receive the draft order within 9 months from that order forwarded to you, DRP shall finalize its hearing and it will issue the final direction within the stipulated period to the assessing officer. One more point that we need to understand is the consequences of the order of DRP. On receipt of the draft order, the assessing officer shall, in conformity with the direction, complete the assessment within 1 month from the end of the month in which the direction is received. So, now the crux which we can draw here is that if you are not agreeing with the assessment order given by the assessing officer in your case and you move to the DRP after listening to you, after maybe understanding the assessee's case before assessing officer, now the DRP will issue the final direction, and those directions are very importantly, they are binding on the assessing officer to be followed. So, what you are seeking here, if you compare the CRT appeal, then the appellant time is usually more than the 9 months, which I have discussed with you secondly, rather than the CRT appeal, which is the alone CRT label person takes care, and here the 3 CRTs are sitting who will be deciding the matter of yours by majority, and the law presumes that they are the most experienced person, so they are maybe to decide your case in a precise understanding. Now, what if the assessee is not satisfied with the DRP direction? If you have submitted an objection to the draft order and now you are not satisfied with the direction given by DRP, the assessee has to wait till the order of assessing officer is passed, then he may file an appeal before income tax tribunal within 60 days of receipt of assessment order. Which form is to be filed before DRP? Form 35A along with facts submitted to the assessing officer, grounds of objection, legal arguments, case laws relied upon. So, the purpose of this particular video is to spread awareness among the non-residents who may not be aware of DRP proceedings. As of date, I hope this will cover the purpose and help you to seek the necessary remedies appropriately through the DRP. Thank you very much for listening to me.